Good afternoon, everyone. I'd like to welcome you to the annual Constitution Day program. My name is Chuck Rozak. I'm Vice Provost for Graduate Education, and I'm here subbing for Ben Vincent, who's traveling today. I want to welcome you all to this event. I want to thank the faculty advisors, Doctors Tartikoff, Luker, DeSwart, Dahl, and White. And I want to welcome our distinguished guests here today, Elora Thomas Lundberg and Hans von Spakovsky, and also the student panelists here. It's a wonderful event. The title of today's program is Battle for the Ballot Box. And as I reached out to my colleague Joe White in terms of some ideas and of what are the topics for discussion today. And it is a very exciting time. I remember when I was a student back in the late 1960s with the Democratic Convention and the riots that were surrounded with that, the controversy about the Vietnam War, assassination of Martin Luther King, and assassination of Robert Kennedy. It was a very troubling time, but students were engaged in discussions about these political events. Today, we have the Democratic debates that are going on, settling on who's going to be the candidate. Voter ID laws, voter registration purges, partisan gerrymandering, electoral fraud, and discrimination against minorities. A lot of important topics in that, and it really is a great event at this university that we can come together and talk about these critical issues that face us today as a nation. So I want to welcome you all once again, and I'd like to turn the program over to Madeline.
Thank you, Vice Provost Rozek. We appreciate your presence and support at this event. Good afternoon, distinguished guests, faculty, students, and friends. I am Madeline Myers, and I am the Mistress of Ceremony for today's forum. It is an honor, today we commemorate the 232nd anniversary of our nation's founding charter, the United States Constitution. It is an honor to welcome both Ms. Elora Thomas Lundberg of the Senior Staff Attorney at the American Civil Liberties Union Voting Rights Project and Mr. Hans von Spakovsky, Senior Legal Fellow at the Heritage Foundation's Election Law Reform Initiative. The Student Discussion Roundtable is grateful that both of you have accepted our invitation to speak and answer questions from our panelists and audience. We live in a time when the right to vote, enshrined in the Constitution, is questioned by individuals across the United States, given state and federal laws and judicial decisions. Therefore, we wonder, is the right to vote a battle for the ballot box? We look forward to the two speakers' thoughtful perspectives regarding the constitutional right. Now, allow me to introduce our student panelists. Ms. Gabrielle Blatnick. Mr. James Fitzgibbon. And Mr. Mamadi Jallo. Finally, please join me in welcoming our moderator, Mr. David McGrath.
Ladies and gentlemen, today we commemorate the 232nd anniversary of the signing of the U.S. Constitution. From its inception, the Constitution has safeguarded certain fundamental rights. Notably absent from the text of that original document, however, is the explicit mention of a right to vote. 4 years later, in 1791, the Constitution was amended through the Bill of Rights, and yet the individual right to vote was still missing. Since then, nonetheless, constitutional law has often focused on protecting the right to vote. The battle for the ballot box continues. Voter ID laws and voter registration purges have recently caught the attention of the public. States must take threats to election security seriously, so there is indeed a balance to be struck. Moreover, increasing controversy over partisan gerrymandering has created another issue for states to address. In 2013, the Supreme Court struck down the heart of the Voting Rights Act, allowing 9 states with a history of voter discrimination to change their election laws without advanced federal approval. And in June 2019, the Supreme Court held that it does not have the authority to rule on partisan gerrymandering cases because partisan gerrymandering is a political question. Such decisions have left an ever-expanding set of questions on voting rights in the hands of the states. The Constitution and recent Supreme Court decisions leave states with challenges to address on their own. Therefore, we have a wealth of fascinating issues to discuss this afternoon. Please silence your cell phones. Ms. Thomas Lundberg and Mr. von Spakovsky will each have 10 minutes for opening statements. Ms. Thomas Lundberg, the floor is yours.
Thank you, and thank you for having me here today. And I was recently at a talk where the speaker started his talk with a Jay-Z quote, "Let me reintroduce myself," and I thought, that's smart. I'm going to steal that. So here I am stealing it. My name is Elora Thomas Lundborg, and I'm a voting rights attorney at the ACLU. Some of my speech was preempted today. I want to talk to you today about the history of voting in this country. It's a history of expansion and retraction of the right to vote. I became a voting rights attorney because of my mother's story. My mother grew up in South Carolina in the 1950s and 1960s and was responsible for integrating her school. There were two things that always struck me about my mother's story of integration in the South. One was her bravery. She integrated her school despite receiving death threats at her home, parents who were outside of her school protesting, opposition inside of the school, both from teachers and students, some of it physical when it came to students. And I wondered, how did an 11-year-old have the bravery to integrate her school? And what other brave people went through challenges so I could have the rights that I enjoyed? So that was the first thing I wondered about. And the second was, this all happened in 1964, which seemed late given that Brown v. Board of Education happened in 1954. Why did it take 10 years for my mother to integrate her school? And all of this had me thinking about the civil rights movement. And so then I became fascinated with the civil rights movement and wanting to study it. And if you study the civil rights movement, you see that voting is at the center of the civil rights movement. Martin Luther King's first speech at the Lincoln Memorial was not his famous "I Have a Dream" speech, but his "Give Us the Ballot" speech. And in that speech in 1957, he argued that what was needed to make Brown v. Board of Education a reality all throughout the country was the right to vote. And without that right, that it would be impossible for African Americans to have true equality in this country. And so when I grew up, I wanted to be a voting rights attorney. And when I thought about where to go, ACLU was the perfect choice. ACLU has a 100-year history of fighting for civil liberties and civil rights in this country, has been involved in voting deeply, including Reynolds v. Sims, which is a 1964 voting case that said one person, one vote. Essentially, everyone's vote is equal. If you're in Cincinnati or Cleveland or Columbus or rural Ohio, your vote should be the same as everyone else's. And then a year later, the Voting Rights Project was started in 1965. And since then, the Voting Rights Project has brought over 300 cases. So when I thought about where to practice voting rights, ACLU was a natural choice. And when I arrived at the ACLU, this was on my desk. It is a constitution. And as was said before, if you look through the Constitution, you will see there's no explicit guarantee of the right to vote. So where does it come from? Well, as lawyers, we read it into the First Amendment and the 14th Amendment. And the 14th Amendment is where I'd like to start my history of expansion and retraction of voting rights, because the 14th Amendment is one of those Reconstruction amendments. And Reconstruction was a period of great expansion of the right to vote. During Reconstruction, African Americans gained the right to vote all over the South, and that resulted in real political power. There were 16 members of Congress who were African American. Up to 600 African Americans served in state houses throughout the South, and hundreds more as local officials. Eric Foner of Columbia estimates that up to 2,000 African Americans served as politicians during the Reconstruction era. And the example, you need to look no further than the state of Mississippi that sent 2 US senators to Congress during that period and had a lieutenant governor. Since then, Mississippi hasn't had a single African American elected to statewide office. That's despite the fact that Mississippi has the largest share of African Americans today than any other state in the country, as related to total population. And the way in which Reconstruction was contracted and the right to vote was limited was by the Union troops leaving and a number of laws that made it harder for African Americans to vote, and the Supreme Court allowing states to have control over the relationship between the races, most famously in the civil rights cases of 1883 and Plessy v. Ferguson in 1896. So in 1896, the year of Plessy v. Ferguson, in Louisiana, there were 130,000 African Americans registered to vote. Just 8 years later, there were 1,342. 90% decline in African American registration. And this was done through 2 facially neutral mechanisms, primarily literacy tests and poll taxes. Now, I've been accused of using legalese, so let me explain what facially neutral means. Facially neutral means that the law on its face doesn't say anything about race. So literacy tests were tests that were given before you could vote, and on their face they said nothing about race, but they were applied in a discriminatory manner. The local officials decided what questions were on the tests and who would pass. Poll taxes, again, were facially neutral, but we're talking about a population that came out of slavery, where they were property, and into being sharecroppers, where they didn't own property and had very little cash. And to add to the poll taxes and their discriminatory effect, many states had grandfather clauses, which said that if your grandfather or your relative voted before the Civil War, then you didn't have to pay the poll tax. So getting rid of these 2 mechanisms became a key part of the civil rights movement, and it didn't really culminate until the Civil Rights Act of 1965, and that act said everyone has the right to vote and it should be equal, and we're going to make sure there are no more discriminatory practices. And one of the keys of that act was Section 5, which said that if you in the past had a history of discriminating before you as a state or a locality changed your laws, it had to be pre-cleared by the government. And so we see then a period of expansion. And that expansion gets us right up to 2008 and the election of Barack Obama, with the most diverse electorate in our nation's history. And that included many students and minority voters. After the election of Barack Obama, after a period of expansion, there is a period again of retraction. In 2010, there were wave elections all over the country, and a number of restrictive voting acts are passed. That only increases with Shelby County v. Holder in 2013, where the Supreme Court effectively ended the pre-clearance regime that I discussed earlier in the Civil Rights Act of 1965. After that, 9 of the 15 previously covered states entered more restrictive voting mechanisms. And that situation is only continuing. Today, there are a host of voter restrictions now that are keeping minority and poor communities away from the polls, from voter purges to voter ID laws to felon disenfranchisement to gerrymandering. Voter fraud is often used as a reason for these laws, but voter fraud is extremely rare. Some academics liken it to getting hit by lightning or sightings of extraterrestrials. With one of the lowest turnout rates among democracies in the world, we should be making it easier for people to vote and not harder to vote. Democracies depend on citizen participation, and we should be making it so that everyone who wants to participate can participate.
Well, I'm Hans von Spakovsky, and I appreciate the invitation to be here today. One of the things lacking in today's society, unfortunately, is the ability to have civil but substantive discussions about issues, particularly controversial issues. Just so you know my background, I have both practical experience in elections as an administrator. I was on election board in Atlanta, Georgia. I was on election board in Fairfax County, Virginia, which are the two biggest counties in their respective states. But I also spent several years at the U.S. Justice Department enforcing the Voting Rights Act and other federal laws on voting before going to the Federal Election Commission, where I helped enforce federal campaign finance laws. So I come at this both from a legal standpoint, an administration standpoint, but since we're doing personal stories, you should understand I come at this also from my family standpoint, which is my childhood was filled with stories from my parents about how easy it is to lose your liberty and how quickly that can happen, because my mother grew up in Nazi Germany. My father was Russian, escaped communism twice before they met in a refugee camp and immigrated to the United States. Now, there's no question the right to vote in a free and fair election is the most basic civil right, and it's the one on which so many other rights of the American people depend. Congress and the states have an obligation to ensure that every American who's eligible to vote is able to vote, but, and this is the second half of the equation, that their vote is not stolen or diluted through fraud, administrative errors, or other problems in the system. Preserving the great experiment that is the American Republic is dependent on free and fair elections. An honor system is not sufficient to protect that right. Folks often say that, well, there's no voter fraud in the United States, we shouldn't worry about it, but the U.S. Supreme Court certainly disagreed with that. In 2008, when they upheld Indiana's new voter ID law, they pointed out that there were flagrant examples of voter fraud throughout our history that have been documented by historians and journalists. And the key to that is, as the Supreme Court said, it could make the difference in a close election. And we have close elections all the time. Before coming here, I went to the website for Ohio and looked at recent elections. And in the last couple of years, I counted up 140 local elections in Ohio decided by one vote or by a tie, which emphasizes the importance of what the Supreme Court said. A couple of years ago, the Heritage Foundation, where I worked, we started a database. It's a database of voter fraud cases. These are proven cases. So these are not cases where someone in a newspaper article claimed that there was a particular problem that they think they saw at a polling place. These are proven cases where someone was either convicted in a court of law of committing fraud, or a judge ordered a new election, or a state election board ordered a new election because of fraud, as just happened in North Carolina. You all may recall the last disputed congressional race in the country after the 2018 election was North Carolina. On Election Day, the Republican was ahead by 900 votes, but when the state board started investigating the case, they discovered that a campaign consultant and his staff were picking up absentee ballots and, in many cases, completing them for the voter. They've been charged with felonies, and as you know, the election was overturned. I checked our list for Ohio. We have several dozen proven voter fraud cases in Ohio, ranging on everything from non-citizens voting, including people from Canada and Pakistan, duplicate voting, false registrations, people from out of state taking advantage of your same-day registration law that you had a couple of years ago and voting, fraudulent absentee ballots, ballot petition fraud, buying votes, and I found several elections that were overturned due to fraud, including city council races in Fairfield, Ohio, and Lorain, Ohio. The point of this is something that the Presidential Commission on Election Reform, this was headed by Jimmy Carter, former Democratic president, in 2005 said, "The electoral system cannot inspire public confidence if no safeguards exist to deter or detect fraud or to confirm the identity of voters." Now, one of the things that was mentioned today was the Voting Rights Act. The Voting Rights Act was probably the most successful federal law passed in the last century, perhaps almost in our history. It changed the face of voting in this country to the point where in places like Mississippi and Georgia, where Black Americans were denied the ability to register and vote, today, for example, in Georgia, Black Georgians are actually registered at a higher rate than white Georgians. And the success of the Voting Rights Act also can be seen in the fact that in the 2012 election, Black Americans voted at a higher rate than white Americans across the country. And in fact, the Pew Research Center just released a study on the 2018 election. Because you keep hearing these stories that, oh, there's voter suppression going on, people being kept out of the polls. Sorry, but the turnout data shows that that is just not the case. Pew just released a study on the 2018 election. The number of Latino voters nearly doubled over the 2014 election. It came close to presidential election year levels. That's very unusual for a congressional race. The share of Black voters who voted climbed 10.8 percentage points in the 2018 elections to 51.4%. Democrats picked up 40 House seats, 7 governorships, and 6 legislative chambers across the country. And as for this idea that something as basic as voter ID keeps people out of the polls, sorry, but the data shows that's just not true. Georgia's law, Indiana's law has been in place since the 2008 election. We have turnout data on the states that have put this in. Not only did turnout not go down, it went up to the point where just a couple of months ago, the National Bureau of Economic Research released a study. They looked at 10 years worth of data from all 50 states to see what effect voter ID laws might have, and here's a direct quote. Voter ID has no negative effect on registration or turnout overall or for any specific group defined by race, gender, age, or party affiliation. The point of all this is that, look, voting is really important. When Rhode Island passed its voter ID law, and Rhode Island is a state, by the way, controlled by Democrats. The voter ID law in Rhode Island was sponsored by an African-American Democratic state senator, by also a state representative named John Bryan, who said, voting is one of the most important rights and duties that we have as Americans, and it should be treated accordingly. I completely agree with that. We want to make sure everyone who's eligible to vote is able to vote, but that we are taking precautions against everything such as election fraud, administrative errors by election officials, and the biggest issue we have coming up right now on the horizon, which is cybersecurity. Because of the fact that so many election officials all over the state are moving online. The biggest development being online voter registration, which almost every state now has. Because of that, they are making themselves vulnerable to hackers and others who want to change election outcomes. And anybody who thinks there aren't people out there who don't want to change election outcomes, I can give you case after case after case of this, particularly in rural counties. This is not one of them, but in rural counties all over this country where the county government, the city government is a source of money, jobs, and resources, people are willing to cheat to win elections. And in many other places, the amount of money given to election officials to do what they want to do, even when they want to do it right, is insufficient for them to do the kind of job that we want them to do. And that's why we see administrative errors in the election area. Voting is important. We should treat it that way. And we should treat it the same as we do other constitutional issues under other parts of the Bill of Rights, like the Second Amendment. Thanks.
Thank you. We will now move on to questions regarding voter ID laws, partisan gerrymandering, and voter registration purges from our student panelists. Speakers will have 5 minutes to answer the questions addressed to them. There will be 3 minutes for rebuttal and 2 minutes for a final response from the original speaker. Ms. Blatnick, you may proceed.
Thank you. A number of states currently have laws that require voters to provide a government-issued photo ID to vote at the polls. The Supreme Court has ruled that preventing in-person voter fraud is a legitimate government interest that may justify such laws. Mr. von Spakovsky, how do you answer critics who say voter ID laws suppress voting by minorities?
I've answered that question. There have been I cited one study, a comprehensive study just released. But there have been numerous studies done about this, including by me. One of the things I did was the ACLU 10 years ago sued the state of Georgia when they passed a photo ID law. And by the way, you all should realize every single state that has put in a law like this has put in a provision that provides a free ID to anyone who doesn't have one. And some of the states, such as South Carolina, have put in another exception. In South Carolina, for example, whose voter ID law was upheld by a 3-judge court in the District of Columbia in 2013, they've put in a provision that says, as long as you fill out a form saying you had a reasonable impediment that kept you from getting an ID, you still get to vote. But the point of this is we've got turnout data for 10 years worth of voter ID in many states. And the turnout data shows that it did not keep people out of the polls. Turnout in Georgia, for example, in the 2008 and 2010 elections, immediately after the ID became effective, turnout went up dramatically. And in fact, the turnout of African American voters and Hispanic voters went up at a higher rate than that of white voters. That's one of the reasons the ACLU lost their lawsuit in Georgia. And in fact, there was a quote from the judge in which he talked about the fact that after 2 years of litigation, the ACLU couldn't produce a single individual who was going to be unable to vote because of that voter ID law. And that's why these laws are in place in many different states, because almost all of the lawsuits filed against them have failed. A couple have been successful, but most of them haven't. And the data now is out, the turnout data for 10 years worth of voting, and it shows it does not keep people out of the polls.
So first on turnout, I'd like to start with Wisconsin. Wisconsin is a state in which we've been litigating and are currently litigating voter ID. And there was a study by Ken Mayer of the University of Wisconsin that found that Wisconsin's voter ID law depressed turnout by thousands of votes in 2016. We are still waiting for the data to know if that is the level of the level that the president won in 2016, but Wisconsin was one of those very divided states. And Wisconsin is also a strict voter ID law. My friend just said that anyone can get a free ID. That, in fact, wasn't the case in Wisconsin until the ACLU brought its case. And you still can't get a free ID in Wisconsin. There is now a process that has been put into place, thanks to our lawsuit, that says that there has to be some sort of free certificate as you're trying to get your ID. And the problem of getting an ID is not just the problem of how much you pay for the ID, but how much do you pay for the underlying documents. So in Wisconsin, we brought our case on behalf of Rucho Frank. She was born in her small town, had voted in that town since 1948. When Wisconsin passed its voter ID law, she did not have the ID necessary to vote, even though she'd been voting for decades in her small town and everyone knew her. In order to get the ID, she had to get a birth certificate, but she was born at home and didn't have a birth certificate. The state wouldn't accept her baptismal certificate, her marriage certificate, her social security card. None of those things counted for her to get her ID. She tried to get a birth certificate, which was $20, so not that much money, but her name was misspelled on her birth certificate. And in order to pay to get her birth certificate name changed, she had to pay $200. For poor communities, that is prohibitive. And many people born at home, born in the rural South, especially in African American communities, just don't have the underlying documents in places that have these strict voter ID laws. And there is a difference between voter ID laws, and we're currently litigating in Wisconsin having an affidavit option. So it's not the case that all states are the same. And my friend mentioned Georgia. Georgia's law, part of it was overturned as a poll tax. Texas's voter ID law was overturned. South Carolina had to allow an affidavit option. It's because we're fighting to keep voter ID not restrictive that people are getting access to the vote.
Do I get 2 minutes?
The Georgia ID law was not overturned as a poll tax. You all can Google it and you can find the case and you'll find that that's not true. Georgia has a strict voter ID law. In the 2018 election, so the one that we just had, black voter registration increased to almost 69%. It was up 6.1 percentage points. Black voters in a state with a strict voter ID law were registered 1.6 percentage points above that of whites. The turnout in the election, 60% of black Georgians voted in 2018 compared to only 43% in 2014. Only 56% of white voters voted. The law has been in place for 10 years. The Wisconsin law is in place because, in fact, the individuals who challenged the law lost, and the law was upheld by the 7th Circuit. And for anybody who doubts that voter ID doesn't have an effect on turnout, like I said, Google this study, National Bureau of Economic Research on Voter ID, which looked at these ID laws across all of the states and found it doesn't have an effect on turnout.
The National Voter Registration Act requires states to maintain accurate voter rolls. Therefore, how can voter purges, such as the one in Ohio, ever be unconstitutional?
So a voter purge can be unconstitutional if you're denying an eligible voter the right to vote. There are cases of eligible voters being falsely removed from the voter rolls. Right here in Ohio, 2 weeks ago, there was a voter purge. Prior to the voter purge, the Secretary of State gave the list to a number of good governance organizations, including the League of Women Voters. The League of Women Voters took that list and found that over 4,000 people on the list had voted in the last 2 years. And this was a list of people who were being purged because they had supposedly moved and not voted in recent elections. There were other problems with the list. For example, people were on the list who appeared as active in the registry that the Secretary of State had, which meant if someone looked up their registration to see, do I need to vote? Do I need to notify the Secretary of State that I still live here? They would find that they were listed as active, meaning they didn't do anything. And that's the problem, is you should not be purging anyone who has the right to vote. In fact, there was recently a case that we won in Indiana. And this is what Chief Judge Diane Wood said about the NVRA and the right to vote. The integrity of the voting process is critical, and one measure to protect that integrity is the voter registration process. A name on a voter roll in Indiana is there only because a voter took the trouble to put it there. Laws such as the NVRA ensure that states do not undo that work without good reason. And so no one should be removed from a role if they are still eligible, because that causes illegitimacy to the voter rolls. And there have been other cases, for example, in Florida, where 80% of the names that were put on the purge list were people of color. The majority of those were Hispanic Americans, including a World War II vet, a decorated World War II vet who had moved to Florida from Brooklyn, was born in the US, and because he had a Latinx name, he was put on the rolls as potentially being a non-citizen. We've challenged other purges, for example, in Texas, where people have nationalized and they've been put on the list as non-citizens. The right to vote is a precious right, and we shouldn't be taking it from people cavalierly. As someone who is a product of people fighting for my right to vote, I can't cavalierly take someone else's right to vote.
Look, I agree that election officials shouldn't take people who are eligible off the rolls, but the idea that they're doing that cavalierly is just doesn't fit the facts. When the National Voter Registration Act was passed, they put in very particular rules. And one of the rules they put in was that if an election official wanted to remove somebody from the rolls, and by the way, they have an affirmative duty under that law to do regular maintenance. That means removing people who have moved away, who have died, or have otherwise become ineligible. And if you don't think that's a problem, look up the Pew Charitable Trusts in a study they did several years ago, in which they found that there were almost 2 million people who are dead still on the voter rolls, and almost 3 million who are registered in more than one state. What election officials do is they try to find people, for example, who have moved out of state so they can remove them from the rolls. Are they always accurate in doing that? No, but that's because they're managing very large lists. Many county election officials have gone too far in the other way. There are hundreds of counties in the United States now that have more registered voters than the census says they have population. And the most important thing for you to understand about this is that even if someone is, through an administrative error, is removed from the voter rolls by mistake, that is not going to keep them from voting. Why? Because in 2002, Congress passed a law called the Help America Vote Act, and it put in a provision called provisional balloting. And what that means is that in every single polling place in America, under federal law, if you show up, and your name is not on the registered voter list for whatever reason, either they mistakenly removed you, or when you registered to vote at DMV made an administrative error and didn't send your name to election officials, as long as you assert that you're eligible and that you did register to vote, you have to be handed a ballot. It's a provisional ballot, and what happens is, after Election Day, election officials investigate your case, and if it turns out it was an administrative error, you should have been on the list, your vote is counted. We did provisional ballots when I was on the county election board in Fairfax, Virginia. Upwards of 60% of the provisional ballots we ended up deciding should be counted because there was an administrative error And that was the reason the person wasn't given a regular ballot. So on the one hand, election officials have to try to maintain the accuracy of the rolls, but there are safeguards built in to be sure that even if a mistake is made, you're going to be able to vote.
So a lot of the data about more people on the rolls and are more people on the rolls and live in the state have been debunked. For example, in California, that's a popular location that is used, and the Washington Post looked at the data and found that in fact that's not the case, that there are more people on the rolls and live in the state. As far as provisional ballots go, often voters have to do something to get a provisional ballot cast. It's not just that you have a provisional ballot, it's cast, and then it's counted. So in Wisconsin, if you don't show up with the right ID, you're allowed to cast a provisional ballot, but then you're given 3 days to show up with the correct voter ID, or your vote is going to be thrown out. So provisional ballots, while they're an important safety net, they are not a catch-all, and people should not be removed in the first place. In Ohio, we had to fight to make sure that provisional ballots were counted of purged individuals who had been improperly given notice about the purge. And it was only through litigation and settlement with the state that we were able to make sure that all of those provisional ballots of people who had been improperly removed because they were not given the appropriate notice under the NVRA are being counted today.
Mr. von Spakovsky, in 2019, Rucho v. Common Cause, a 5-4 decision, left in place North Carolina's congressional districts favoring the Republican Party, as well as Maryland's map favoring the Democratic Party. Despite this ruling, many citizens and organizations continue to work at the state level towards the establishment of fair redistricting practices. What does fair redistricting entail?
That's a very good question, and it's one that the Supreme Court was unable to answer. Here's what you need to understand about this. Look, nobody likes gerrymandering, and it's been with us since the beginning of the country. As you all know, it's named after the governor of Massachusetts because the district that he drew looked like a salamander. But the important thing to understand here is it is a political question. And it is not up to the Supreme Court to decide that engaging in politics violates the Constitution, because that's in fact what the Supreme Court case was about. The challengers in that case were saying that if you engage in politics when you draw district lines, you're violating the Constitution. Well, there's always going to be politics involved in line drawing. So I call this the Goldilocks principle of gerrymandering. If there's always going to be politics, what the Supreme Court was being asked to do was to draw a line where, well, you can engage in some politics, but you can't engage in too much politics. And at some point, it becomes unconstitutional. Well, there's no way to draw a line there. Look, the answer to this is for states. States are in charge of line drawing under our Constitution. That was handed to state legislatures. Some states have switched over to an independent redistricting commission. But the key to this, if you don't want lines drawn that favor one particular political party, is to make sure that the standards under which lines are drawn are strictly put into the state law or the Constitution. For example, you don't want towns and cities broken up into 6 different congressional districts? Fine. Put in a rule that says, as much as possible, the line draws have to keep towns, cities, communities together. They have to be contiguous. They have to be compact. That's the way to fix that, not to get judges who are unelected federal judges drawing lines. One of the most amusing things that I saw in this case that was before the Supreme Court was that there were briefs filed saying, oh my goodness, these congressional districts in North Carolina are the most partisan we've ever seen in our history. Well, whoever wrote that, the lawyers that wrote that obviously don't know our history, because one of the amicus briefs that was filed in this case before the Supreme Court took a look at the congressional districts drawn after the 1864 election. Okay, you all recall, in 1864, right? Abraham Lincoln was reelected, but the Democratic candidate, former general, who you all know, in many states, he got upwards of 40, 45, 49% of the vote. Well, when the lines were drawn in a number of states where the Democrat got such a high percentage of the vote, there wasn't a single Democratic congressional seat. Now, you want to talk about extreme gerrymandering, that's an example of that. Now, the one thing I would caution on this in this area is this. A lot of people are pushing this idea of going to independent commissions. Okay, well, the problem with independent commissions is that who appoints the members of those commissions? Governors, state legislatures, people who have an interest in the outcome. And the one thing you can say about state legislatures, even when they engage in redistricting, is if they're drawing lines and you as voters don't like them, you can work to get those people out of office. It may be hard, but you can at least try to work to get them out of office. You can't do that with redistricting commissions. When those commission members are appointed, they are basically unaccountable to voters. So if you don't like what a redistricting commission does, you can't vote those folks out of office. And there was a study just released, and I wrote about it for National Review, that took a look at one of these independent commissions, the one in California, and it showed that they actually drew very partisan districts where they supposedly were not supposed to be doing that. So gerrymandering is always going to be a problem, but the idea of handing this over to unelected federal judges to decide how much politics is okay when you're drawing lines would have been a big mistake.
So my friend just mentioned the Goldilocks conundrum, and then said that we should expect the state legislators that are currently the most gerrymandered in history to write laws limiting their gerrymandered seats. I would say that is the Goldilocks proposition, that if we leave it to the gerrymandered current legislators, we're not going to get different seats. And fortunately, Ohio is a state that has passed a citizens initiative to set limits, and it was through a citizens initiative that that was able to happen. It's happened in other states, but that's rare. Not every state has what Ohio has, which is the ability for the citizens to directly take to the ballot and change the laws and the way in which things function. And what gerrymandering really is about is that voters should pick their politicians and not the other way around. Election outcomes are predetermined in gerrymandered maps by the legislators themselves. So in Ohio, there is a 12-4 map for 4 election cycles. That includes in 2012, where President Obama won the state, and in total, Democrats got 47% of the congressional vote in the state, but only 25% of the seats. That also includes 2018, where again, Democrats got in 47% of the vote and only 25% of the seats. That also includes Maryland, where I co-authored a brief on behalf of the Republicans who had been harmed by gerrymandering in the state, where one of the districts was taken away from the Republicans. So Maryland is now an 8-1 state, despite the fact that Republicans have 33% of the vote. And gerrymandering is the real threat to the confidence in our democracy. Voters feel like elections are rigged. We heard it all throughout our case here in Ohio. Time and again, our plaintiffs were telling us about how they felt as though their vote did not count because they knew the same guy was going to get elected, and there was nothing they could do about it. Justice Kennedy acknowledged this in Veith. He said, "It's unfortunate that legislators have reached the point of declaring when it comes to apportionment, we are in the business of rigging elections." And talking about elections in the 1860s before apportionment and one person, one vote, which is Reynolds v. Sims, is not a real analogy, because then states could draw any kind of map that they wanted. They could put one person in a map before the court stepped in and said, no, that is not appropriate. You cannot have malapportioned districts. And it's unfortunate that the Supreme Court did not step in here and allow federal courts to, but there are still state courts, and we saw that in North Carolina, and I'm hoping to see that in more state courts.
The one thing I would say about this is that Elora actually made the argument that was made in the court, which is also fundamentally wrong under the Constitution, which is the idea that the Constitution guarantees political parties proportional representation. Sorry, but that's not in the Constitution. And what I mean by that is the fact that a statewide candidate for one political party wins a state, whether it's by 51% of the vote or 60% of the vote, doesn't mean that that political party is guaranteed 60% of the state legislative seats or 60% of the congressional seats. That kind of thinking doesn't take into account the fact that many voters split their votes. You can look at you can look at districts all over the country. Wisconsin's a good example, where you will find that, for example, the voters in a particular district may have elected a Republican to the state legislature, but voted for a Democrat for Congress or the Senate. People split their votes, and this idea of proportional representation for political parties does not take that into account. The Constitution guarantees your right to vote and your right to have representation. It doesn't guarantee representation to political parties.
Ms. Thomas Lundborg, to what extent is the purging of voter rolls necessary for fair elections, or has purging become a partisan tactic in order to further the goal of voter suppression in certain districts?
So I think a reasonable list maintenance program is obviously legal, it's constitutional. We all want to have an accurate list, but an accurate list also means that eligible voters are not removed from the list. I mentioned Ohio and the inaccuracies found here. I'll just give you one example. Jen Miller is the executive director of the League of Women Voters. She voted 3 times last year, and she's on the Secretary of State's confirmation list as having not voted and having moved out of the state, even though she's the executive director of Ohio League of Women Voters. And that's where it's problematic. But it's not just problematic because individuals like Ms. Miller are put on voter purge lists. It's that we know that voter purge lists fall disproportionately on minority communities, that when states especially enter into list maintenance programs saying they're trying to find non-citizens, it affects minorities. So for example, in Florida, 82% of the voters who were going to be purged were non-white. 60% of them were Hispanic. A federal judge this year blocked Texas's attempt to purge voters, calling the effort ham-handed and threatening. And people who are purged, one of the issues is that if it's done incorrectly, they don't even know they're purged until they show up to vote. So for example, Larry Harmon was one of our plaintiffs in our Ohio purge case. He voted in 2008, he was purged in 2015, and he didn't find out until he went to the polls in November of 2015. In New York, 200,000 people were improperly purged and didn't find out until they went to the polls to vote. And that was by an investigation by the Attorney General. So when we remove large numbers of people and disproportionately poor people and people of color from the list, it affects our democracy. Martin Luther King said that the denial of the sacred right is a tragic betrayal of the highest mandates of our democratic tradition. And then, as I've said before, The provisional ballot does not solve this issue because often a voter needs to do something to make sure that provisional ballot counts. And when we're talking about communities where it's already hard enough to get off work to go and vote, are you going to go and track all the necessary documentation you need to go back again to maybe not even your local polling place? It might be an administrative office far from your home, far from where you live. A lot of people just can't do that, and their votes end up not counting.
You're getting the impression that these election officials just simply delete people's names off the rolls. That's not the way it works. They go through this long, involved process to actually try to find people who have moved or died or otherwise become ineligible. And to give you an example of this, Congress told the states, this is in the motor voter law, that they could use the NCOA system. That's the national change of address system run by the U.S. Postal Service. And you all probably know, under that system, if somebody sends you first-class mail to your home address, but you no longer live there or you've moved, the Postal Service sends that letter back to the person who sent it to you with a notice telling you you've moved. So a lot of states use this system. If the letters come back, they don't immediately delete people. They contact, or they try to contact the registered voter to find out whether they have left or not. If the registered voter sends them back a written notice saying, you're right, I've moved, then they can take them off the list. If they don't hear anything from the voter, they can't take them off the list. Not until another 2 federal election cycles have passed and they have not voted. I don't dispute that sometimes people are mistakenly taken off the rolls, but the point is it's very easy to get back on, and you're going to be able to vote if you show up at your polling place. Why is this important? I'll give you a quick example. After the 2016 election, the Government Accountability Institute, this is a nonprofit in Florida, and you can look this, you can Google this and look up this study. They bought the voter registration lists and voter histories from 21 states. They supplemented this data with commercial data from commercial data houses. You all would be astonished, probably shocked at how much information commercial data houses have about you. So they were able to supplement the voter registration information with the full Social Security numbers of voters. They then ran a match. No false positives with the full Social Security number. They found 8,500 people who illegally voted in more than one state in the 2016 election, including 2,200 in Florida, a state that has decided a presidential election in 2000 by only a couple of hundred votes. That's one of the reasons it's important for election officials to try to maintain the rolls. Do they always do it correctly? No. But in the vast majority of cases, they do. And they have safety measures in place for when they do make an error.
So I think we've already discussed why those safety measures are not the kinds of safety measures that, in fact, guarantee that your vote is counted. I've cited a number of examples, including right here in this state, where the purge or list maintenance process is not working as it was designed to work by Congress. I think we could agree that if the list maintenance programs worked as written in the NVRA, a lot of my work would be easy because we wouldn't be sending as many letters and filing as many notices with states to let them know that they're not following the NVRA's mandates.
Thank you. We will now take questions from our audience. We have Spencer Luckwitz in the corner and Andrew Ford. They will be running around with microphones. Students in particular are encouraged to ask, but we will start with the gentleman in the blue.
I have a question for Ms. Lumberg. What is the corollary to black codes that have done south in terms of voting rights, and what is the trajectory in terms of these different types of euphemisms of voter suppression? is there a relationship in terms of the context historically relevant to the suppression of African Americans or Latinos within this country? And is it suppression? And how would you define suppression, being that? And then is there a historical relationship to this after antebellum South Reconstruction?
So I do think there is a historical analog between what's happening now and what happened during the Black Codes. As I mentioned in my opening, the Black Codes themselves, many of them were facially neutral, meaning they didn't say anything about race. You would have to know how elections worked in the particular jurisdictions, about the difference in socioeconomic status between voters for the suppression to be evident. And that's what's happening today, is that a lot of these laws on their face are racially neutral. In fact, they all are. But in practice, minority communities are targeted. So take voter ID. I mentioned that not only do you have to pay for an ID, you got to pay for the underlying ID. That is prohibitive for poor communities. And in the US today, race and socioeconomic status are still linked. So if you're poor, it's more disproportionate that you're going to be African American or Latino. So that's one reason why the voter ID laws and trying to get all the IDs, and they limit the kinds of IDs. So in Wisconsin, there are a lot of local IDs that are free that don't count in the voter ID law. And so one of the things we've litigated, and we're in fact still litigating, my friend was incorrect to say that our case is over. It's very much still alive in Wisconsin, the Wisconsin voter ID law, to try to get an affidavit option. So someone can say, as they can in other states, I did everything I could to try to get an ID. I still have been unable to. Please let me vote.
Anyone can check it out.
Yeah.
Would you consider this to be an invidious collateral sanction? Would you consider this to be an invidious collateral sanction as we look at those who are formerly incarcerated, those who are transient populations, those who are homeless? Is this a collateral sanction based on a particular demographic and social act that is in practice acting in a benign, passive-aggressive way?
It definitely has an invidious effect on these communities. And you mentioned felon disenfranchisement. We didn't get a chance to talk about it today, but in 1850, 35% of the states had a felon disenfranchisement law. Many of those laws were passed during Reconstruction, and today 96% of the states have them. Felon disenfranchisement is another way in which minority communities are kept from the ballot box. And as I said earlier, voter purges are disproportionately among minority communities, especially Latinx communities, and Texas and Florida are just two examples.
Let's start with the gentleman in the gray.
No, you have to wait to make sure that you have microphones.
Yes, exactly. Thank you.
First, in Ohio, if you're in jail for a felony, you do not vote. You can be tried for a felony and vote, and you can have your right restored when you get out. Also, if you're in jail for misdemeanor, you vote. I worked for the Board of Elections and actually went to the Warrensville Workhouse once or twice to aid people in voting. The question I wanted to ask is, what exactly does Section 2 of the Voting Rights Act of I think it's Section 2 or Section 5 of the Voting Rights Act of 1965 say about the creation of minority-majority districts, and how is that not gerrymandering? For, in my case, I'm in the old Lou Stokes district, which is now Fudge, which is the African-American east side of Cleveland, the African-American part of Akron. What do the people in Brecksville have in common with those two communities that is forced to be drawn into their district?
Is that a question to me?
Either. In fact, I'd like both of you to answer.
Okay, do you want to start? I'll respond.
Just to explain what he's talking about, there's probably, 24 lawyers in Washington understand the complexities of Section 2 of the Voting Rights Act. But here's what you need to know. In 1965, When Congress passed the Voting Rights Act, they passed Section 2. Section 2 is permanent, it's nationwide. And Section 2 prohibits racial, ethnic discrimination in voting. This has been interpreted by the courts to require states under Section 2, if they have a history of discrimination and a whole series of other factors, to create what are called majority-minority districts. In other words, these are districts in which members of a racial minority, whether it's Asian American, Hispanic, African American, whatever, have the ability to elect their candidate of choice. Now, the only way that the courts have decided that can be done is if, for example, African American voters are a majority in a particular district. So on the one hand, it's racial gerrymandering, and that's what's going on with these Section 2 cases. And even there, state legislatures are in a real bind, because what the courts have said in interpreting Section 2, which requires protection of racial minorities, and the Equal Protection Act. The Equal Protection Act of the 14th Amendment is where the court said, one person, one vote. That means that congressional districts, their populations have to be as equal as possible. And so what state legislatures are put in this awkward position of, they have to consider some amount of race when they're doing redistricting to protect racial minorities. But the Supreme Court has said that if race is your primary factor in drawing districts, well, then you're violating the Equal Protection Act. So a little bit of race is okay, too much race is not okay, and they have to, legislators have to try to draw this line in between the requirements of the Voting Rights Act and the Equal Protection Act, and that can be very confusing. And if all you have to do is look at North Carolina, where in the last case before the court making racial discrimination claims, depending on which set of judges you looked at in the federal courts and the state courts, they all had different opinions about the different districts and whether there was unlawful discrimination going on. So it's a really confusing area of the law, unfortunately.
So the reason that we have Section 2 is, as I said, this all goes back to the history of Jim Crow. So what Section 2 is really there is to say that if you have a significant number of African Americans in a community, and it has to be, compactness is in fact one of the requirements of Section 2, which means you can't grab communities all over the state to try to make an African American district. These are people who are living together in community with one another. It's trying to prevent then that community from being cracked. So saying if there are enough people living here that are all of a minority group, then they could have a district where they could elect a candidate of choice. And a candidate of choice does not have to be an African American. In fact, I argued in our most recent case that a candidate of choice is whoever the group of people together want. And that could be a candidate of any color, but it's saying that a community, and because of race and socioeconomic status and a lot of other political factors are still together in the US, that try to draw a district. But that district does not, in fact, have to be majority minority. The court recently said in Cooper v. Harris that it just has to be sizable enough to elect a candidate of choice. So in Cuyahoga County, you have, in fact, more African Americans that are necessary to elect a candidate of choice. And we argued that the 9th district going down into Akron was done not to meet the requirements of Section 2, but as part of the partisan gerrymandering that happened, and that Section 2 was used as a cover by the map drawers.
Students, we want to hear students' voices. Students, please ask questions, please.
Yes. And please specify which speaker or if both you're addressing your question to, yes, and wait for the microphone. So.
Students come first now.
I know we didn't really get to talk about this. I guess I'll address this to both of y'all. So in terms of felons that are now out of prison and have barriers to voting, and it varies by state, whether you have to like wait a certain amount of time or pay a certain amount of money, I was just kind of wondering like what the layout was in terms of litigation of whether there's any action being taken to try and kind of allow those people to have easier access to vote once when they're not incarcerated anymore.
On felons, first of all, you need to understand that that is a right granted to the states by the 14th Amendment. So it's not something Congress can change. There have been bills constantly dropped in Congress to change it, but the 14th Amendment specifically gives the states the ability to do this. Now, in the majority of states these days, felons automatically get their right to vote the moment they're out of prison. There are other states where you have to apply to get a pardon, and some states, Virginia, although that's been kind of overridden, had a waiting period. Here's what I would tell you about this. Look, I think felons at some point should get their right to vote back. But I think that's up to the people of each state to decide. Having a waiting period is actually a pretty good idea, because if you look at studies, including put out by the U.S. Justice Department, the results are uniformly, unfortunately, that 75% of felons are back in prison within 5 years. So actually having a waiting period makes a little bit of sense. I tell you, the one hypocrisy that I find about this is that many of the folks who push and say that felons should immediately get their right to vote back the moment they're out of prison, even if they haven't, for example, completed probation or parole or any court-ordered restitution to their victims. They never talk about the fact, and I don't see a push by them. You know, they always say, well, the felon has paid his debt to society, and a way of getting him reintegrated into the community is to give him his right to vote back. Yeah, but you don't just lose your right to vote when you're convicted of a felony. In most states, you lose all kinds of other rights. You can't own a gun under the Second Amendment. You can't sit on a jury. There are many professional licenses you can't get. And in many places, you can't get a job as a public school teacher or as a police officer. Yet, the folks that I talk to or debate on this who are pushing for the right to vote to be immediately restored never talk about all of these other rights. You know, there was a referendum just passed in Florida in the 2018 election. They went from a process where you had to apply to an automatic restoration. That referendum only restored the right to vote, not any of the other rights that a felon loses. And my argument would be, if you believe that a felon has paid his debt to society and that he should be reintegrated, then why aren't you working to restore all of his rights, not just his right to vote? And that's the question I would ask folks who are pushing to restore the right to vote, but not any of the other rights the felon has lost.
So the Supreme Court in 1886 said the right to vote is preservative of all other rights in Yickwo v. Hopkins. It is distinct from all the other rights that my friend just listed. Because without the right to vote, you don't have the protection of any other right. For example, we vote for our politicians, and in many cases our judges, and if we don't vote for our judges, we vote for the politicians, who then appoint the judges, and those people interpret all those other laws. So if you can't even vote for those people, and they know, those politicians know that you don't vote, why would any of the laws reflect your concerns? For example, a felony could be a drug conviction, even drug use. And when I was in law school, one of the big things we talked about was the difference between crack cocaine and cocaine as far as how much you had to pay, how long you had to be in jail. I'm sorry, I have an alarm going off. Just give me 1 second. This is telling me to pick up my daughter, and I'm not going to pick her up because I'm not in New York. Sorry about that. I thought I had turned everything off, but not the alarm. Anyway, getting back to felon disenfranchisement. So about the difference in conviction and sentences. And unless you have a foot in the door, then you have no say over that. Lyndon Johnson, the signer of the Civil Rights Act, said, "A man without a vote is a man without protection," meaning that you have to vote in order to protect all of your other rights. And just a couple of additional points on felon disenfranchisement. The number of people who've been disenfranchised due to felonies has increased dramatically in this country. As I said earlier, it was 35% of the states in 1850 had felon disenfranchisement laws. Now 96% of the states have them. In 2016, 6.1 million people in the US cannot vote because of felony conviction. And my friend is incorrect that the majority of people are in jail or prison. In fact, 77% of the people who can't vote because of felony convictions are out of jail or prison. These are people living in our communities who have not regained the right to vote. In Florida, what Amendment 4 did was give back the right to vote, because Florida actually was one of the states that took away your vote forever. And the Florida amendment was led by a man named Desmond Meade, who spent 3 years in prison 2 decades earlier and still had not regained the right to vote. In that time, he'd gone to college, he'd gone to law school, and became a lawyer. His wife was a politician, and he couldn't even vote for his wife because of a drug conviction 2 decades earlier. And we also know that felon disenfranchisement laws, just quickly, have a racially disparate impact. 1 out of 13 African Americans is unable to vote due to felon disenfranchisement. 1 out of 56 non-African Americans is unable to vote. In 4 states, Florida, Kentucky, Tennessee, and Virginia, 1 out of 5 African Americans can't vote because of felon disenfranchisement. And again, I don't think these numbers are surprising given the fact that felon disenfranchisement laws came out of post-Reconstruction and Jim Crow.
Okay, we have time for one more question. We will go to the young lady in the back.
So you've spoken to the role of gerrymandering and voter registration in its role in limiting, or whether or not you believe it has a role in limiting diversity of political opinion. I was wondering if you could elaborate on whether or not you think the Electoral College has a role in limiting diversity of political opinion.
You want to go first?
Okay. So we've come out against the Electoral College, and I'll just say quickly why. It's often said that the Electoral College helps small states because otherwise they'd be ignored in the presidential races. The 12 small states with 3 to 4 electoral votes are Arkansas, DC, Delaware, Missouri, North Dakota, South Dakota, Wyoming, Hawaii, Idaho, Maine, New Hampshire, and Rhode Island. The majority of these states still get no presidential campaign attention, New Hampshire being the significant outlier here, which is where presidential campaigns go is to battleground states. And the small states that are currently getting just the minimum number of electoral votes are not battleground states. They're states that are firmly in one column or the other column, and so campaigns are not going there. And so, but those less populous states still have an outsized say in who is president, despite the lack of attention from presidential campaigns. So the 12 non-battleground states have about the same population as Ohio, 12 million. But those 12 states together have 40 electoral votes, where Ohio only has 18.
On the issue of why people don't vote, I suggest that you all take a look at a survey that the Census Bureau does after federal elections. They do surveys and they go and they talk to people who didn't vote, and they also talk to people who didn't even register to vote. And the idea that, for example, voter registration issues, things like that, keep people from voting, or voter ID keep people from voting, the surveys show that's not the case. The vast majority of people say they don't vote because they're not interested in elections, they don't think it'll make a difference, they don't like the candidates, they don't like the political parties. You know, that's a cultural, societal issue if you want to change that. On the Electoral College, the whole point of the Electoral College, as it was originally expressed in James Madison's notes at the convention, was to prevent a presidential candidate from being able to win the presidency by just going to the big cities and the urban areas and ignoring the rural, less populated parts of the country. That is still just as true today as it was then. Yes, the smaller states get less attention, but the smallest state in this country, no matter how small it is and how tiny its population is in comparison to the rest of the country, still gets 3 Electoral College votes. So if you switch to a national popular vote system, those states would get even less attention than they do now. And the point is that a candidate, we should have somebody who's elected by a broad swath of Americans, not somebody who's just elected by people in the urban cities. And that's the point of the Electoral College, and I think it still is relevant today. Thanks.
Thank you to our audience for their questions. Each of our speakers will have 2 minutes for closing statements, and we will start with Ms. Thomas-Lundborg.
So I just want to close. You may have heard a lot about study this and study that. There's just been a lot of studies looking at voter fraud since we spent a lot of time talking about it today. Justin Levitt looked at voter fraud. He's from Loyola Law School. He looked from 2000 to 2014 and found only 31 credible instances of voter fraud. That was when 1 billion votes were cast in that period. My friend mentioned his own study. That study goes back to 1950. So if there were 1 billion votes cast between 2000 and 2014, how many votes were cast in that period? And I think their study found 11,000 of billions and billions and billions of votes. Kenneth Mayer looked at this issue. He's from the University of Wisconsin. He said the proportion of the population reporting voter impersonation is indistinguishable from that reporting abduction by extraterrestrials. Richard Posner, who is a Ronald Reagan appointee and was on the Crawford panel, said it was wrongly decided. And in our case in Frank, said that the instances of voter impersonation and voter fraud is exceedingly rare. This is a lifelong Republican judge saying this. My friend made similar critiques of voter fraud in a case we had in Kansas called Fish, and the judge there found those claims not credible, and she said they were not credible and that many of the instances just did not happen. I mentioned the Martin Luther King's speech, give us the ballot, and I just want to read a portion of it. Give us the ballot and we will no longer have to worry of the federal government about our basic rights. Give us the ballot and we will no longer plead to the federal government for passage of anti-lynching laws. Give us the ballot and we will fill our legislative halls with men of goodwill. Give us the ballot and we will place judges on the benches of the South who will do justly and love mercy. Give us the ballot and we will quietly and nonviolently, without rancor or bitterness, implement the Supreme Court's decision of May 17, 1954. Brown v. Board. Voting rights are as important today as they were in May 1957 when Martin Luther King Jr. gave that impassioned speech. They are under attack today, and that's why the ACLU and other voting rights advocates continue to fight to make sure that everyone has the right to vote.
Well, I'll end by saying I'm sorry that you ended this debate by attacking me personally because you don't like the evidence and the facts that I brought up. The voter fraud database we have does not go back to 1950. It starts around 2-3 decades ago, and it is not a comprehensive list. It is a sampling of voter fraud cases from across the country. For those who say this is unimportant, it was important to the people of Gordon, Alabama, whose mayor was removed in January of this year after he was convicted of voter fraud in an election that he won by only 16 votes. It was important to the people of Maryland just a few years ago when the congressional party candidate who won the primary in the 1st congressional district was forced to get out of the race. Why? Because someone within her own party did opposition research on her and discovered that she had registered to vote in both Maryland, where she was running for Congress, and in Florida, and had voted twice in multiple elections in both states. She withdrew and was convicted of voter fraud. That's just a small example of this. Voting is important. It's just as important as so many other rights that we have, and we should treat it that way. And that means, as I said before, we need to make sure that everybody who's eligible is able to vote, that elections are administered as effectively and as well as possible by election officials, and that people don't take advantage of the vulnerabilities of the system to either dilute people's votes, steal people's votes, or to cause such administrative errors or other problems through, for example, cyber hacking, that we don't have a fair election system. And I don't think that trying to get rid of some of the vulnerabilities means that you are a vote suppressor or anything like it. I think it means that you want to ensure that everyone's vote counts. Thanks.
Ladies and gentlemen, the Student Constitution Discussion Roundtable expresses our sincere appreciation to Ms. Thomas Lundberg and Mr. von Spakovsky for joining us today. We give special thanks to the Office of the President and the Provost, as well as to Vice Provost Rozek for attending on their behalf. We would like to thank our many contributors. Please hold your applause until the end. The ACLU, the Heritage Foundation, the School of Law, the Department of Political Science, the Center for Policy Studies, the CWRU chapter of the Federalist Society, our student panelists, moderator, timers, and volunteers, and our wonderful advisors, Dr. DeSwart, Dr. Dole, Dr. Lucker, Professor Tartikoff, and Dr. White. At this time, everyone is invited to proceed outside to the Black Air Lounge where we will be serving refreshments. Ms. Thomas Lundberg and Mr. von Spakovsky will join us to answer any remaining questions that remain. Thank you.